I'm Jeremy Warriner. I am a bilateral above knee amputee, which means that both of my legs were amputated from above the knee. That took place 17 years ago while I was commuting home from the hotel that I was managing. My background is as a assistant general manager and a director of operations in larger hotels in convention markets. And then that particular incident occurred after I had switched to a smaller hotel on a university campus. And from there, I went on to be one of the charter members of the Rotary Club of World Disability Advocates. And I also have my own organization, Walking Spirit, which provides accessible diversity, equity, inclusion, and belonging assessments, consulting, and training specifically from a disability lens. Coming to you today to raise awareness of an issue that was actually heard before the United States Supreme Court this past Monday, and it is an issue that could impact the civil rights of people with disabilities throughout the United States. Understand that the Americans with Disabilities Act is different from the Civil Rights Act, and there are a lot of aspects that are different about it, but it defines protections for people with disabilities from discrimination based upon their disability or perceived disabilities. And it also lays out how that protection is to be put in place throughout the public sector, as well as state and federal government and local governments. And so when it comes to the public sector, understand every hotel built after 1990, which was when the Americans with Disabilities Act was signed into law, every hotel has to be accessible and comply with the Americans with Disabilities Act. Now, if the hotel was built before 1990 and no modifications have been made, then it does not have to comply other than to the fullest extent possible without making any major financial changes or structural changes. But once you do have to comply. The issue up in front of the Supreme Court at this point is actually about how that is enforced. And when the Americans with Disabilities Act was put into place, it was recognized that the people best equipped to enforce the ADA were in fact the people protected by it, people with disabilities. And so what has currently been heard is a case involving a person who is considered a self-appointed tester who has been, and this person has filed many lawsuits against hotels, many of which are smaller hotels, for not having appropriate access online for people with disabilities to be able to reserve an accessible room. Accessible rooms are vital to people with disabilities' ability to travel. And understand a disability does not mean someone is disabled and that they can't do things. It means that accommodations need to be made so that they can achieve the same goals. In this case, the goal of travel, which everybody has a right to in this country, that is something that's why hotels need to be accessible. So when you look at the ADA, it will talk about things and say, if your hotel has 50 rooms or less, you have to have one accessible room. Now, again, if you were built before 1990, you don't have that unless you've made some change where it's required for you to make that upgrade and comply. So in this particular case, a woman who is blind and uses a cane and a wheelchair to assist in her mobility has, as I said, filed several lawsuits against lots of different hotels around the country because they have failed to make their accessible rooms available for reservation online. In the 2010 updates on the Americans with Disabilities Act, they included that all hotels and all sporting events and anything that any person with no disability can make a reservation for online a person with a disability needs to be able to access the same way. So I find myself on the fence because as a person who used to work in hotels, I do understand that there are hotels that were built before the Americans with Disabilities Act existed that are still within that safe harbor because they have not made any structural improvements that would require them to add and come into compliance with the Americans with Disabilities Act. That said, they should try to comply to the fullest extent possible. And that does mean having some kind of statement at the very least on the website about how they can make a reservation for an accessible room. If they don't have an accessible room, they need to be clear about that. And I would go so far as to suggest that if a smaller hotel does not have accessible rooms and therefore would not have them available online, they should go so far as to list on their website a recommendation where a person with a disability can find an accessible room in their market. That's not required, but that is the recommendation that I would put out there for any hospitality organization that is not accessible to everybody. And part of the issue here is also, as the plaintiff in the case maintains, is that the hospitality industry will not comply with the Americans with Disabilities Act unless they are forced to through lawsuits. And that is unfortunately a fair assessment of the way that the hospitality industry has approached being compliant with the Americans with Disabilities Act, and more to the point, being accessible to over a quarter of the population that lives with physical or emotional or cognitive disabilities, or complex disabilities that involve all of those. And that quarter of the population in the United States, that quarter of a population is also connected to lots of family, lots of friends who would be able to travel easier if the hospitality industry was fully accessible. So the concern, the risk to the civil rights of people with disabilities in front of our current very conservative Supreme Court is whether or not people with disabilities will be able to consistently hold organizations accountable for not complying with the Americans with Disabilities Act. There are no ADA police. There certainly are ADA codes that as buildings are built, they need to comply with, and building inspectors will look at, but the ADA doesn't necessarily lay out what the best way is to do those things. It's in some cases not very clear on guidance. It will tell you how many inches a toilet needs to be from a wall. It will tell you how many parking spaces you need to have in a parking lot based upon how many parking spaces you have. But it doesn't necessarily tell you the common sense that those accessible parking spaces need to be as close to the main entrances of the building, and that they need to be as free of obstacle as possible. So this is why people with disabilities are supposed to be the people enforcing the Americans with Disabilities Act. And you need to understand that the Americans with Disabilities Act was specifically put in place to be a civil rights law protecting people with disabilities from discrimination that could only be strengthened by case law and by legislation, that could not be weakened. That was the original intent. In 2017, the US Congress passed a law called the Americans with Disabilities Act the Americans with Disabilities Act Education and Reform Act, or the ADA Education and Reform Act. That piece of legislation was meant to address drive-by lawsuits, which one could see this as falling under, but the way that was done, it put a requirement on a person with a disability to communicate in writing with the organization that they feel is discriminating against them, to educate them about how they were discriminating against them, then give that organization time to respond in writing, and then a timeline in which to make changes. But it puts a restriction on the person with a disability from being able to file an Americans with Disabilities Act complaint until they have taken the step of educating the organization or person discriminating against them. It is the only piece of civil rights law that I'm aware of that requires people with disabilities to take the step of educating the discriminator themselves rather than filing the complaint and allowing the discriminator to become educated in their process of complying with the Americans with Disabilities Act. I am very, very concerned that our Supreme Court, with its current makeup, is not going to consider the original intent of the law to make certain that it could only be strengthened by case law and that it could only be strengthened by legislation. In this case, this is case law, and their responsibility is to strengthen the rights of people with disabilities by making it clear that people with disabilities have to be able to test. And if they are following the process as it should, that they have to be able to enforce that organizations that should be compliant, and that includes any hotel built after 1990 or updated after 1990, they have to be compliant with the Americans with Disabilities Act, including the ability to reserve a room. So this is absolutely why it is so vital that people with disabilities are included and consulted when it comes to accessibility, and they need to be listened to. They need to have the equity at the table to be able to help organizations that are there to provide a service to the public, a service regarding lodging and food and dining and entertainment and aspects of human life when traveling, that those organizations have got to be proactive about helping and supporting people with disabilities in their independent effort to travel. Which is why having accessible reservations available for accessible rooms is vital, and this case needs to be heard. And the Supreme Court needs to strengthen the Americans with Disabilities Act by supporting this case so that it can move forward.